different lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, yo, folks, it is Tuesday. It is Tuesday. And we are still, I haven't seen if, from yesterday, I haven't seen if TK, if the jury has come back with sentencing yet. The choice, yesterday we finished off with more or less the jury being sent home and being brought back today. And sometime during, I suppose, they should be done. But I have not seen what it was. So let's do some morning docket thing with, we'll be starting out with Judge Simpson, and then move on to Judge Boyd. Just this casual Tuesday, not Karen Reed, anything. Let's have a good old-fashioned stream looking at court and trial and stuff, but no Karen Reed. Okay, folks? Are you all okay with that? So let's start with looking at Judge Simpson private. Oh, by the way, I'm going to put this up now. This is my work, which means that as long as you attribute the clips to me, clip away. Just clip away. Okay. All right. Let's go ahead.
Congratulations. Appreciate it.
I was going to say congratulations, but not seeing it. What does that mean?
Sorry. Next week.
I mean, that'll freaking weird. You can get
Yeah,
your
I think I'm sitting there.
You're gonna make that.
Paul Ryan, 14A District Court, the County of Washington, State of Michigan, final session. All those having business for the court are near. The Honorable Judge J. Cedric Simpson.
You may be seated. Are we ready on anything? Please? Okay, but I need a waiver.
The people with any conflict between the Honorable Court and the Office of the Public Defender for all cases on today's docket, this will be make this waiver for the appointment? Okay.
One of the short issues is just on the check. You also have to relate the compensation. You would wait.
Thank you, sir. And the court also does not believe there's conflict either in the Michigan court rules or the case decided there under to the extent a conflict does exist, given the way which the court will be the matter. They're at the door. Who's that? Oh, no, he's just saying, okay, got it. Court does call the case, People versus Matthew Wright.
If you ever make that for people.
I'm sorry? Oh,
Oh, thank you.
thank you. Okay. What are we doing?
Your Honor. Maybe approach me really quickly.
That's how you want to start my day?
Mhm.
Fine, fine. You're not asking. Jerry says I'm not asking. Yeah, come on. Good approach.
Okay. Judge Simpson and going private. Well, just for a short period of time. Here he is again.
All right. Record to reflect the bench conference.
Your Honor, this is the exact same preliminary exam. I did explain to counsel that it appears we are not able to proceed at this time. We anticipate that we may be able to, once we can get a hold of any witness in this matter. And we will be authorizing the case promptly as soon as
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is on defendant's motion.
Oh,
Thank you.
congratulations, defendant. You are out.
Court does call the cases of the People versus Tybee Mill.
Anderson is appearing on behalf of the people, Your Honor.
Good morning, Attorney Kevin Bassanti, 71061. On behalf of Mr. Tybee Mills, the president to my right, Mr. Mills, get your next election.
Thank you.
Today's the date time set for preliminary examination of all three of these cases. Mr. Bassan and I have been talking. I don't think there's an objection. We'd be looking to adjourn all three. The primary reason is that the victim in the armed robbery is in the military. He is active duty, but in speaking with the officer in charge, he is willing and should be able to make accommodations to come up here to testify during the examination. We just needed to clear things with his command, and they are apparently willing to allow him that leeway to come up here. I believe he's in North Carolina right now. And so we're looking for that, and also the officer in charge on the more recent Bonnet case from 2025 is Officer Kessler. So he's also unavailable. We spoke with the court staff, and I'm not picking a date, but I'm just throwing a possible date out there of May 13th for an adjourned examination on all three cases.
And Judge, that's all right, yeah, on behalf of Mr. Mills and his benefit, just for the record, Judge, I would object to an adjournment for this witness not being here today. In the preliminary exam, the witness was subpoenaed, so for the record, Judge, I would object to an adjournment.
All right. In the court, the witness being the individual in the military.
That's correct.
All right. And the court will find good cause to adjourn if the defendant is in military service and can't get up and walk in here. I don't know if this is the type of case, but certainly the court would, if there's no objection for the defense, would also accommodate testimony by Zoom. But
And I'll let Mr. respond. We spoke about that, and I understand his position. I don't think that would be it.
yeah, it would. Okay. And I understand that in terms of that. So what I will do is then I will grant the adjournment given that finding good cause. I'll adjourn the preliminary examination to May 13th. That's when everybody's available and where the accommodations could be made to have the individual.
It's best.
Oh,
That's correct, Judge.
May 13th, 2025 at.
And, you know, me and the people approach on a medical issue concerning my client.
Certainly.
Oh, sorry. Yeah, it seems to be a criminal docket in Judge Simpson's court this morning. Let's see if there is any clippable moments. I'm sure you all have seen some of the clips that are out there, and Judge Simpson is a judge that is very easy to have these 1 to 5 minute things with. Now, I prefer to stream it. Now, if it's especially funny, yeah, I will try to clip it out and put in as a short or a short form video or something of that sort, both on Rumble and on YouTube's. Hello.
Did he show up? What? Did he? Didn't he? Didn't I tell you if he walked in to take him out? Was that just
Good man.
who? No.
That's a woman who is a bit tired.
Court does call the case, People versus Leon Booker.
And then on behalf of the people, Your Honor.
For some people. That's a way to argue about that.
Oh yeah, hours ago. But don't worry about it. No, I thought you were here all day. Yes, it has. Thank you.
Your Honor, at this time, people are under count one. I would ask the court to remand count 2 to district court.
Be brandishing in public.
Correct, Your Honor.
All right. So I'll dismiss count 1, maintain the plea of not guilty as to count 2. This matter will be set for pretrial 1482 District Court on
April 30th at 9 a.m. before the court.
April 30th, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
All right, thank you. And we'll continue.
Hi, Sasha. How am I? I'm doing good. I'm traveling a bit tomorrow morning, my time. I'm going upstate in Sweden, so for Easter, and yeah. So I'm doing good. So yeah, streaming now for a few hours, and then at 5 p.m. Eastern, me, Dave, and Andrew Branca are going to start the coverage of the Michigan versus Schur case. And that would be interesting. Detective Schur, a few years ago, 2020, I believe, shot it's a white cop shot black suspect, claims self-defense type of case. So we will start that at 5 p.m. today. So in just under 5 hours. I don't know if I will do stream all the way up to there, but if yeah, let's just wait and see. Hi, Gwendolyn. Hi. And hello, Michelle. Hello, Gigi, J-Town, Cripple, Nicola, everybody at YouTube, and hello, everybody over at Rumble. At the moment, not streaming on X. I don't know why, it just chose not to.
Yes.
What is Simon doing? What? He did. So what are you doing? What are they doing? To me. Court does call the case People versus Demetrios Mastapops Delapis.
And
Why are you laughing?
Your Honor, Joseph, on behalf of, state your name. Demetrius Mastapostolis.
Okay, I got everything but one syllable in there. I was close. All right.
Oh,
Under today's date time set for preliminary examination, at this time, I would ask the court to amend count 1 to make an attempt interfering with electronic communications. And then we would ask the court to remand on counts 1 through 4 to district court.
Okay, I'm not gonna be able to do it that way.
After count 1.
I have to, yeah, because what has to happen is count 1 would be dismissed. And then he would go down to on counts 2, 3, 4, and 5, which would become the attempt.
I'll go fill up my coffee. I'll be right back.
I'm gonna need the pack code on that one. It's likely gonna be 75545A with a bracketed A.
Correct, Your Honor.
Mr. Simon, any objection to that?
No, Your Honor, thank you.
I would order that the people are to file an amended complaint in the case so that everything is clear.
We'll get that out to you.
And as to count 5, your client is standing mute to that judge.
Thank you, Your Honor. Yes.
And the court will enter a not guilty plea, maintain his not guilty pleas to counts 2, 3, and 4. Count 1 is dismissed. I will set a pretrial before Judge Freshour,
April 24th at 10 a.m.
Judge Fresh Shower?
April 24th, 2025, 10 a.m.
Ay, damn it.
Your Honor, can I ask a quick question? Is that here?
Yes, it would have to be. It's here.
Right. Okay.
May 6th, I don't know if that was, she called out.
That what? Who?
May 6th. Yeah.
That would be greatly preferred. It's a DV. She likes to hurry the DV docket. But this is a client who's already been to court, been admonished on his bond condition. That's what she likes to do, and I'm not criticizing that. I'm just stating it factually.
So May 6th,
May 6th.
10 a.m. before Judge Freshour.
Thank you.
Bond will continue. Thank you.
Another one of these, okay, what's going on in day-to-day basis. And you know, I enjoy covering the big trials for you. I really do. But I think this is very educational to see the day-to-day, what's actually going on behind the headlines,
What does
and stuff like that.
call the case of the people versus, is it Risha Cheatham?
There you go. Andrew Childers, bring on behalf of people, Your Honor.
And when we are in the style.
Mr. Simon, get out of the way.
I'm so sorry, Your Honor.
Miss Young was too nice to say that to you, but I'll say it.
Thank you.
Good morning, Your Honor, for the record, reading out 244626. Appearing on behalf of Mr. Shield, two judges present, standing to my right, and to state the name for the record.
Grace Cheatham.
Thank you. And she's waiving her right to preliminary examination.
Yes.
Is that correct, young lady?
Yes.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed in, or the offense alleged was committed in that you committed it. Do you understand you'll not have that hearing? You'll proceed to circuit court for further resolution. All right, people also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Young. You
Well,
waive,
as to the payment on the information waiver, as the court did or not guilty plea. Sorry, Judge.
no, it's okay. Defendant every way formal reading, pleading not guilty. Court will enter that not guilty plea to that charge. Pretrial in this matter will be set for
June 10th at 1:30.
June 10th, 2025, 1:30 before Judge Conkey.
Thank you, Commissioner.
Thank you. And, can I speak of counseling back, please? I'm young on a separate matter. Yes, please.
Yes.
All right. Court is standing agreement.
All right.
Okay.
All right. Dun, dun, dun. This seems to have been a short morning docket. Ah, they're back.
House on this way, like if it's a one way in this town, you know, cancel it, like get up speed and try to one way. It's like we used to, what else is working?
All right. The 14A District Court for County of Washington, State of Michigan, is now back in session.
Maybe seated. Court does call the case of the people versus, is it Saquon Hala Middle?
If you were to the for people.
However, on behalf of Angela Middleton, she wants to.
Morning.
Judge Simpson is as good as pronouncing names as Dave.
All right. What are we doing?
So we're have tendered a plea. The offer is to plead to one count of larceny 200 to 1,000, and one count of larceny under 200. Ms. Middleton intends to enter a no contest plea. I've shared the police report with Ms. Vineline.
I had it and I've reviewed it.
Thank you, Judge.
So the plea form indicates that the defendant will be pleading no contest to the charges of larceny less than $200, the 93-day offense, and also count 7 of larceny 200 to 1,000, the 1-year offense. Upon a successful no contest pleas to those charges, counts 1 through 5 would be dismissed and must repay $700 or $700 in restitution.
Yes, that's.
Is that the people's understanding of the full agreement?
And the court say,
May I have her sworn?
You solemnly swear to affirm the testimony about the truth, the oath, and the justice.
And it is this court's understanding that you are going to plead no contest to 2 charges. Is that your understanding? All right. First charge is the added count 6 of larceny less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Understand that? Count 7 is charge of larceny, $200, $200 to $1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. And $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? All right. Do you understand what a no contest plea is? All right. Let me explain 2 things about a no contest plea just to make sure. You need to understand about a no contest plea. First of all, it means that you're not further desirous or want these charges. You understand that? Yes. All right. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea?
Lack of recollection.
All right. So, ma'am, to the charge of larceny less than $200, how do you plead? To the charge of larceny, $200 to $1,000, how do you plead? Now, you understand that by pleading no contest, you'll not have a trial of any kind. All right. You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights? No? Please look at paragraph 5. Those are your rights, which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form. Is that a yes?
Yes.
All right. You understand you're giving up your right to appeal of right. Are you on probation or parole?
Yes.
Okay, were you on probation at the time of this offense? All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 15-13022. Any objection to the court having reviewed that report?
Nothing, people.
Mr. Burdell, any objection to the court having reviewed the report?
No, Judge. My apologies.
Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court?
People satisfied.
Defense is satisfied.
Court will accept the defendant's no contest pleas to 6 and 7. Counts 1 through 5 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be May 14, 2025, 9 a.m. That is before me. Bond will continue in this matter. All right, thank you. Young lady, since you're here on the left-hand side as you walk down the hallway is my probation department. Just stop in there and check in with them so they can start the process regarding something. Okay, thank you. Court does call the case People versus Desiree Walker Johnson.
I can recommend it for people.
Carolyn Foster Tucker on behalf of Desiree Walker Johnson.
Thank you.
And Your Honor, we will be waiting.
Okay. So Walker Johnson, is that correct? You're waiving your right to a preliminary examination? You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Wait formal reading standing.
Defendant having waived formal reading standing mute, court will enter a not guilty plea. Pretrial will be set for
1:30 for the study.
June 5th, 2025, 1:30 before Judge Slay. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you.
All right. First, thank you, Brandon, for $5 super chat. Denmark Invasion Fund. I will make sure to use that for the next time Sweden decides to reappropriate areas of land that should already have been ours. And yes, DK Cripple, there is a YSL trial part 2 upcoming in June. I will, of course, cover that. It is the 3 remaining defendants. So it's actually 2.5 years of 2 years of me covering that case is still not done. And that should have started now in April, but it didn't because one of the attorneys had prior commitments, so they rescheduled it to June. So yeah, that case is never going to end.
Court does call the case of the people versus Derek Graham.
And is that on behalf of the people, Your Honor?
All
During
two.
the behalf of the defendants, both matters. Yeah, John.
Thank you.
We are today's the date and time set for preliminary examination. At this time, as case 24 FB 1431, the people are unable to proceed as to count one as that count to be remanded to district court. And in case 25 FB 1109, people would ask the court to add count 2 of misdemeanor stalking. The PAC code 750.411H, and we are unable to proceed as to count 1 would ask that count 2 be remanded to district court.
Your Honor, with regard to, and apparently I have the case numbers reversed, but it doesn't really matter at this point. In both matters, Your Honor, I ask that the felony charges, count 1 in both files be dismissed.
All right. In the case ending in 1431, that'd be the easiest one for me to do. I will indicate count 1 is dismissed. Continuous plea to count 2 of not guilty. I'll set a pretrial in that matter at 14B for. Yeah, for in custody. Before I give you a date on that, let me.
We're gonna ask the court for bond on that matter, Your Honor, so if they could just take care of the other matter, we can address both cases.
All right. And so dismiss count 1. You're adding misdemeanor stalking. In the PAC code on that.
750.411. It's 1 year, $1,000 fine, 5 years probation.
Just 411.
Correct.
All right. 1 year, 5 years probation. Good.
I'm sorry, Your Honor, my client was asking me a question.
No, it's okay. And so you waive any further formal reading of that and are not guilty pleas to that. All right. Count 1 in that case is dismissed. I'll set pretrial in these matters. All right. In both cases, pretrial will be set April 28, 2025, 9 a.m. before Judge Washington. And as to bond, Mr.
Your Honor, bond was, and I apologize because I forgot to look and see what the bonds are in these matters, but whatever they were set obviously at a time when Mr. Graham had felony charges pending. Those 2 felony charges have now been dismissed. Mr. Graham understands that if the court does allow him to be released, whether it's on a PR bond or a low cash bond, that if he violates bond in any way, those matters could be reinstated. And I'm sure Mr. Graham does not want that to happen because today is a step forward with those cases dismissed. Your Honor, I'll have to ask Mr. Graham, the address I have for him is a Detroit address because that's who contacted me to represent Mr. Graham. I'm sure the court is going to ask if he's released, where he would be staying. And I would ask if the court would consider a PR bond with a GPS tether, no contact, no go to. I think it would be appropriate in this situation.
I have, just speaking of addresses, I have a Miami Avenue in Ipsy.
So
Miami Avenue in Ipsy.
that would be his home address, Your Honor. I just didn't know what the alleged victim was also at that address.
Well,
She's not.
my no go-to is for Dakota Avenue, so I don't, is that, all right, okay. All right, so people's response.
Sure, we would object to any modification about, we were in contact with the victim as recently as Friday, and she was on board the prosecution. We haven't heard from her today, and we have great concerns as to that aspect. But also in this case, we have great concerns given the threats that the defendant was sending to the victim, including threats to shoot her, to kill her, kill one of her kids, saying things, I'm about to kill one of your kids, bitch. As soon as I get my money and buy me a gun, I swear to God. And then the other case, saying things along the same lines of wanting to kill her kids. I swear to God, I'm going to shoot up in that bitch. I'm going to hit one of them bitches in the head. I'm going to catch one of your kids and I'm going to mark your ass. I don't care about going to prison. I can't wait to catch some of your kids. I'm going to kill you broad ass daylight. So I have great concerns given the nature of these threats and given that we have not had contact with the victim today, but did recently on Friday and that she was on board. We have great concerns. And I also believe he has a hold out of Jackson County for trial support as well, Your Honor.
If that's the case, I was unaware of that part. Your Honor. The part about Jackson, that could be addressed if he's really stopped by here. Your Honor, in regard to the threats, I know this court knows it's not unusual in a case of this type for the people to have contact with the witnesses or victims a day or two before when they don't show. This certainly is not the first time that's happened. All I can tell you, Judge, is something happened to the victim between last Friday and today. It wasn't my client because he's been sitting in the Washington County Jail. Yes, he may have made some threats. I can't dispute that because I'm assuming those were taken from jail calls. But yeah, when someone's sitting in jail, particularly at the beginning, they get upset. I understand that, but obviously no one's been killed that we know of.
And Your Honor, these threats were from
Yeah. Again, jail calls, you get told when you make the call that it will be recorded. It's not smart to make threats on a recorded line. Not especially if you're trying to get out on bond.
police report, not from jail calls. They were
Okay,
from
sorry.
what he sent the victim's phone that led to charges.
So he was out. He was not in custody when he allegedly made these threats, and nothing happened to anybody. So Mr. Graham doesn't get insulted. What's running his mouth? Right?
Yeah, I don't think that will work. Wait.
When he's out, is he working? Or
He's been in custody for a while, Your Honor, I assume. So I don't know the answer to that question.
got it.
Charge set up for April 1st, and I said it on this misdemeanor. And they had that prosecutor was Woods, and it was addressed, so it should have been a problem. But I had a job, I was gonna start April 1st. No, I think they need to go to bond, but she said she wanted something after this case.
Right now, his bonds are set at $100,000 cash surety in each case. I'll reduce the defendant's bond in each of these cases, $25,000 cash surety in each case. Defendant must be placed on a tether, which is a previous order prior to any release. Now, the only I don't know. Oh, okay, they both do. The tethers, as they read, are exclusion zones around the Dakota address. So, sorry. All right. Thank you.
Right, just one moment. My client seems to think that the bonds are $50,000.
10% bid.
Did they get changed at some point?
So the bonds I had originally were both 100,000 cash surety, but we're not.
Plus up to 20 cases.
And then he has a misdemeanor case of now he's saying that come out,
Yeah.
within 14 feet.
So it's
So
reduced.
he's at the bottom that he's referring to.
Oh.
It's 100K cash surety.
Yeah, that's right. That's what I had.
That's for the felonies.
On these two cases, I had 100,000 cash surety on each case.
What's worth it? Jeff.
All right. Thank you.
Thank you.
He was right here.
I did see him come in, but I didn't see him walk out, so.
Feaster. Where'd he go? What? What's he doing? Is he just messing around doing nothing? He's just standing there? What, loitering? Oh, him and McDuffie. Oh, boy. About time, Feaster, you showed up. Huh? We've been waiting for an hour.
Judge Moore, I apologize.
Oh, you rather be there?
No, Judge.
No, really? I'll tell her that. Got it. What are we doing on your case?
Thank you, Judge. I'm going to do a waiver of circuit court on this matter. This time there's no misdemeanor offer. My client is in custody. And she won't get this one.
Did you want to go talk to him before they're doing this, or
She knows.
she knows?
Okay. Yeah,
I haven't called it yet. Yeah.
Can we give it to Greg?
I have a bit of a dusting problem because there's a tractor somewhere pulling up a lot of dust. So I'm sneezing all the time.
Court, that's called the case of the People versus Haley Gregg.
Maybe we're two different people.
Courtroom, please, for Assistant Public Defender on behalf of Ms. Gregg. Ms. Gregg, when you do the podium, please state your name for the record. Here you go. Thank you, Judge. State time set for preliminary examination in this matter. I ask welcome to Mr. Duffy, Ms. Gregg. At this time, the case has been offered to the light this time, second court, further resolution.
Ma'am, is that correct? You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive the right.
Yes, right.
Preliminary examination have been waived. Defendants bound over to circuit court on count one with two following.
Thank you, Judge. We'll wait for a reason to stand.
Defendant have a waive formal reading. Standing mute to both counts. Court will enter not guilty plea. Pretrial will be set for
May 7th at 1:30 for Judge Conlon.
May 7th, 2025, 1:30 before Judge Conlon. Bond will continue.
Judge, I just want to address.
Oh, go ahead.
Thank you, Judge. My understanding, Mr. Duffy, is that Ms. Gregg does not have a full history. Obviously, this case, the allegation is that Ms. Gregg is acting out of character for herself. She is ready to take responsibility and resolve this matter, test the waiver. She is asking the right to consider the reduction of her bond and a proper release. She has no problem with attendance. She would have no problems with attendance and following our court orders. In the meanwhile, I'm going to look into possible treatment courts for Ms. Gregg. And she said that she would follow the conditions. I believe she wants to address it. I didn't really want to talk about what happened in this case. Why don't you want to talk about, I didn't have why I didn't do like court this and I had other issues, but my truck was stolen and my phone wasn't there. So I, you know, it's not really an excuse, but I didn't really have a way to communicate with anybody, and I was scared. I didn't know if I've ever been through this situation. I usually, if I get arrested, I find myself out when I come and I pay my fees. This has been a terrifying experience. I'm not used to acting this. I don't know what else to say other than I'm sorry. If I was going on a character, I wasn't on medication.
So,
Yeah, I've been on my medication. I've been.
okay, let me ask you this. You failed to show, the reason she's in is because you failed to show in February. And I issued the bench warrant. So let me ask you this. What happened after you didn't make that court appearance? What'd you do?
Really nothing. I tried to survive out there. I was homeless. What Judge Simpson doing is.
Okay.
Why did you not come set because of his office or court? I didn't know what to do. Like I said, I was scared.
Okay, that's what you were talking about. Okay.
Mental health proceedings like that.
Okay. So let me ask you this. How'd you come back into custody? What happened?
Somebody actually told the police where I was at, and they knew that I had a felony warrant, I guess, and they came to the hotel, and I didn't know, that's how much I don't know. I opened the door. I was like, hi. They're like, hey, I'm like, hey. They're like, yeah, let's go. So I was like, all right. Yeah,
You mean that's how you were talking to the police?
yeah. We're okay. We're good. I mean, I don't, the police, they don't really bother me. They know that, you know, they like me, but they don't.
This sounds like an issue that this kid was off on medication. It sounds like she's not on her medication. It sounds like she's been in custody since
I've been in there 21 days.
21 additional days. She has no problem with the tablet, 100% necessary. She's hoping around consider release. There's some fact that she's waiting, it's taking some responsibility, responsibility. It's better resolved.
Any response from the people?
Your Honor, I don't have any, objection to her getting released. I'm not sure what the situation is now, where she's going to stay. But given that the location, I think, of the night incident was around the Banana Center, she mentioned she didn't have stable housing. So if there is a tether order, a GPS tracking tether might be appropriate.
Well, I'm not gonna put her on a tether. She has enough problems trying to find housing and put a roof over her head.
I mean, the last that I did have, I was there
And then you're gonna have to get back on the list to get, I know how it works.
I am, that's why I was so upset with myself. Like, I'm in the house, like, the housing list, you know what I'm saying? I don't know how this all works. You know how it works.
And so he understands the difficulty you're gonna have trying to get back into something for the sake.
I'm gonna stay here.
That's not what he said.
Oh, I'm terrified right now, I'm shaking.
You what?
I said, I'm just terrified, I've never.
You're shaking right now?
No.
Why, do I make you nervous?
No.
Why do I make you nervous?
It's the high pitch, yeah.
Is that what it is?
It's the height for me, sir.
Oh, okay. Like, such a kind and gentle soul. I don't know why. Whoa, Emily didn't have to have that response. Wow. Alan, you could have stuck up for me. You could have. No. Wow. Everybody's just turned on me. All right. Miss Gregg, here's what I'm going to do. I'm going to reduce your bond. All right. In this case, I'm going to reinstate it back to what it was, to a $15,000 personal recognizance bond. Now, in doing that, Ms. Gregg, you got to make sure your next date is the 7th. You make sure you get there. You hear me?
Yes, sir. Yes, Your Honor.
Okay.
That face.
You didn't even think that would happen, did you? Okay, you get out today.
Thank
You're welcome. Take care of yourself. Wow. She did better than you.
Oh, and thank you, Nana Misty, for being a member for a whole year. Saying good day, Nick, mods, and chat. Hello, Nana Misty. Good to have you here, and thank you for your continued support.
Thank you, Judge.
Alan wasn't gonna do anything. He just, see, Alan, you sorry. Wow. Is that it for us? 14A stands adjourned.
All right.
Okay, that was the final of Judge Simpson. Ended with a bang. Ended with a bang. Now let's head on over to Judge Boyd's court. Dun dun dun. For her morning docket.
All right. I'm going to call the docket. When I call the docket, you need to let me know you are here. If you don't respond, I'm going to assume you're not.
And she has roses, same as yesterday, and a green handbag. And I learned yesterday that most of her handbags are gifted to her by her mother. That is so sweet. Tammy says, Nick, I'm happy to be back here watching. I never knew I was unsubscribed. Yeah, check if you're subscribed or not, because sometimes YouTube chooses to unsubscribe people. And it's very, very annoying. I have had people, even members, reaching out to me thinking I stopped YouTubing because they don't get my videos and streams. They don't get notifications anymore. And that's really annoying. So please check that you're still subscribed and also that bell button thingy.
Here, and a warrant may be issued for your arrest. And counsel, we don't allow defendants on the first row.
Oh, I didn't know that.
Yeah. Yeah. Security issues. I always tell people I stay in my lane. So I'm not in charge of security. The deputies are. I don't court report. The court reporter does. So I just do this.
Thanks, Judge.
Sure, no problem. In custody, we have Randy Folsom, Dustin Newkirk, Josephine Marroquin, Ruben Maldonado. Renee, you need to start driving your clients down.
No, that's my job description.
Gabriel Martinez. Thank you. Eduardo Medina.
President, Council, Judge, we're referring, confirming with the state on this case.
All right, thank you. Sebastian Gonzalez. Where is he? All right. Darren Fish. Darren Anthony Fish. Here we go. Matthew Alexander Insuriaga. Thank you.
Please stand up.
Conrado Vidarui. I know I'm mispronouncing that.
Present for him, he's in custody.
All right, thank you. I'm going to work on that name. Eugene Navarro, Adrian Holmes, custody. Emilio Lopez. Thank you. Hilodoro Willers, custody. Dalvin Berry, Logan Denny, custody. Daniel Morales. Thank you. Ted Kalanga. Daniel Morales, custody. David Moses Escobedo. Heather Pippin, custody. McIntyre Noon, Reginald Tyrone Green.
Custody, Judge.
Oh, thank you. Johnny De La Rosa, custody. Victor Anthony Fernandez.
He's present with counsel, Judge.
Thank you. Ruby Caceres, that has been canceled. Paul Brian Bell. Dustin Newkirk. Is he in custody?
You.
Yes.
Yes, Judge.
All right, thank you. Victoria Villarreal, custody, Jesus Antonio Santolo. Malik Lampkin, Juan Garza, custody, Joshua Jacob Cannon. John Thomas Hayes, custody. Is there anyone who's present and your name was not called? All right, so this is what's going to happen today. We have a jury trial. That jury trial is going to be concluded today. It's starting back up at 12:30. We are recessing at 11 so that the staff can have a break, a lunch break, and then we're going to move on to that trial. If your case is not concluded, you're going to be called back on Thursday. Everybody in the gallery, if you don't see your attorney here, you need to pick up on the phone and call them. Otherwise, no questions asked. You're going to be recalled on Thursday. So you have the court's permission. If you don't see your attorney, to step outside, call them, tell them they need to be here. Otherwise, we're cutting it off at 11. There's not going to be any rushing the bench at 10:59 because the staff needs a lunch break. All right, attorneys, I'm going to repeat the rules because I've noticed that when I don't, people don't follow them. So you're not ready to approach the court unless you've conferred with the state and conferred with your client. If your client is in custody, you need to confer with them. If your client wishes to speak to the court in a language other than English, whether you speak the language or not, we're going to need an interpreter call down. Just when you approach the clerk, just tell them you need an interpreter. I'm going to call you in the order of appearance. The only exception to that is if you have an interpreter because we have a limited number of interpreters. If your client is receiving probation or you think you worked out an agreement where you want them to have probation, or if it's a motion to revoke, you need to talk to the probation officer because I'm going to ask them for their opinion. Probation officer is right there, Miss Abrams. So please confer with her as well. All right, everyone. They tell me it's Tuesday. Feels like it's a Wednesday, but it's not. It's going to be a great day. So everyone, please confer.
I'm doing pretty good. I'm here on, I can't even pronounce his name. The top guy. And I'm gonna go check in tomorrow. Let's wait till I get back.
Bidart? Yeah, I'm not. I'm about to say, looking at the two.
See you guys. I downloaded the Discovery last night. It was still at. I haven't read the.
Marina.
But you go.
Well,
I have to check in it for him before I ask.
103 for you of the authorshiп. 4 years of work.
Folks, just a brief interruption here. Court TV and Barbara, let's see here. Barbara of Court TV, Barbara McDonald, have received exhibits from the Delphi trial of Richard Allen, and they have published it. So, and I briefly checked what's in there, and they were sent the matching exhibits of the cycled versus fired cartridge. Oh, there's going to be a rant, folks. Oh, there will be curse words. Because seriously, if that is that toolmark examiner's evidence of matching, she needs to be fired and charged with lying to the court. If that is what she determined was a match. But I will save that because I already have planned this stream and the stream for 5 p.m. with Dave and Andrew Branca. So I have to save that for another day. But I can promise you guys, all gloves are off. All gloves are off. Oh.
She mentioned that the one. If it goes out on it, I think.
Matthew into Riaga.
This is, salt trade. Yeah, because it's I'm on the list of here, so. Correct. That's what I think. But I think it should be just regular 30-day check.
What page is that on?
I don't know. It shows. Again,
Okay, can I see that file? And let me just make sure it's in the system.
You can see it. The readers need to come in here.
All right, thank you. Students are going to be here tomorrow at 8, but they're not going to start till about 8:30.
Judge? Judge,
Yes,
may we approach Eduardo Medina?
yes.
It is a failure and stop render
That's the
aid.
file on that water, Medina, please. Yeah. And counsel, you're here and your client is here.
Good morning, Your Honor.
Good morning. All right, so we're here for discovery and an offer being due.
Yes, the offer has not been made. Mr. Braswell has been conferring with Mr. Garahan.
Mhm.
And I think this is the sort of case in which Garahan would prefer to make whatever offer first,
Okay,
rather than defer it to my judgment.
all right. So let me give you a date to come back. Why is it-
And I bring it to the court now because I'm skeptical that Garahan will be down here in time.
Okay. All right, so what we're gonna do is we're gonna recall you. Ms. Ferguson, on Eduardo Medina, recall him for May 6th. And at that time, the state will tender an offer to you. And then your next setting, I'm gonna give you a plea deadline date.
Okay.
And then if things are not worked out at that time, then your next setting will be a jury trial date.
Sure.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Judge.
And counsel, do you know if you have all discovery?
Yes, Judge, I do.
All right. Well, then,
Shall I generate a discovery?
yes.
acknowledgement, Judge?
So once you sign the acknowledgement of discovery, you're excused. And once you sign the reset form, you're excused.
Thank you very much.
All right, thank you.
Judge, maybe excuse.
Yes.
You have the seats are taken to. Thank you.
I mean, if she wanted, she could drag anybody into her court. Maybe not jail them, but definitely if she wants people in court, yeah, she can drag them there. Oh, we had some major crimes on yesterday's streams. Yesterday's stream, that was really interesting. We had the abuser of minors who got 15 years. And what else did we have? Yeah, and Judge Boyd's rant against a person who had a girlfriend and a wife and kids with both. So yesterday was interesting.
Yes.
I know. That's why I never could find it.
I'll tell them to pull the file for me.
I was wondering about that when I read the. Which can I approve?
Is it on Mr. Logan? Who is it on?
Kenny Logan,
They're gonna pull the file for me,
they,
and then we'll take care of it.
he's not here. They didn't bring him over.
Oh, no, I understand. So they're pulling the file, so just give me a moment.
Yeah.
Or not. All right, counsel, they say your client is unstable, aggressive. I don't know if that's mental health or not, but you'll need to file a motion if you deem that he needs an evaluation to file that motion.
I'll do a jail visit, see if he comes down for that. If he doesn't, I'll file a motion.
All right, we're gonna recall this for May 8th to see what the status is.
Okay, Judge.
All right, Ms. Ferguson, Logan is being recalled for May 8th. All right, thank you.
Thank you.
We will take that up.
I do have closed captions on. I don't know why it doesn't show anything.
State, on Gabriel Martinez, cause number 2025 CR 000172. Can you see if the PTD has been done? Gabriel Martinez, if you can come forward, please. Hello. Hi, do you know, did you sign any paperwork for a contract for PTD? Do you know if you did that?
Sure.
All right, do you know when you completed that?
I say maybe 2 weeks ago.
Oh, 2 weeks ago?
Yeah.
Okay, they're gonna double check too, but your attorney is currently across the hallway in a jury trial. So Ms. Ferguson, I need a PTD date.
I think you might wait to submit it. I don't know what happened. I know he's been very busy with the trial. I'm not working on it.
All right, we're gonna see, the state is gonna check before you go to make sure it's been accepted. All right, so we're gonna give you a reset for May 20th. But before you leave, we're gonna make sure that it's been accepted, okay? Just have a seat and the court coordinator will give you a reset form.
Judge,
Yes,
I can answer your question.
yes.
Pretrial diversion accepted to program April 1st, 2025.
All right,
Get the agreement sent to the defense the same day.
all right, thank you. All right, and thank you for dressing appropriate for court. The court coordinator is gonna give you a reset form. Let your attorney know the new date, okay? All right. Come here. And Mr. Martinez, your attorney, I don't know if they've started jury trial yet or not, but I know he's right across the hall. So if you want to see if he's there to give him that, you can, or either you can just call him. All right, have a good day.
Skipping ahead so we can get to the interesting stuff.
Darren Anthony. Darren Anthony Fish.
Darren Anthony Fish, what do they allege that you have done?
Jesus Santalo. I think that's been reset. Can I see the file, please?
I'm so sorry to hear that you got arthritis. It is a B. I have it in my knees. My left knee is basically gone. And you have in ankles and feet. That's bad. That's not fun at all. Yeah. I'm so sorry that you're going through that.
Bashan, on Jesus Santello, that is just for update to see how he's doing, correct? Or does he have a motion to revoke? All right,
I have a court summary, and it's for, yes, it is a motion to revoke.
all right. So his attorney is out. It's being recalled for May 12th. Remember, that should be on the docket for May 12th. Santello. Yes, late for court. Hello.
Hello.
Hi. Thank you for dressing appropriately for court. How old are you?
19.
All right. So,
Looks young.
yes. Well, I mean, because he is young.
Yes, he is.
So what is happening with this case?
We're gonna work it out, I think, Judge, so if I can get a reset to have him start and hopefully complete a couple of the things that the state's asked him to do.
All right.
Yeah.
So,
Sorry, just as far as discovery visit's been completed, I've tendered an offer for resolution to them that would take maybe 30 days to get.
okay. All right. So here's the thing. You're in adult felony court, and I'm telling you this for your own good. This nonsense that young people are doing, it will come back to bite you when you're trying to further your career and do other things. So you need to make sure that you stay on the straight and narrow. And if there are any friends that are out there who are pulling you away from the straight and narrow, they're not your friends, because they should be wanting the best for you instead of having you come into felony court. You understand? Because you see the people in the box, those are people who are brought over from the jail. All right. So do better. Okay. All right. So you want a 30-day reset?
Yes, please.
All right. Ms. Ferguson, I need a 30-day reset.
Thank you, Judge.
May we
Oh, once we get the date.
Sure.
All right. May 20th.
Yes.
Are you in school?
No, man.
All right. What are you doing with your life?
I finally went to the Marines.
Okay. All right. Well, I tell you
Been
what.
accepted, Judge, and so if we can get this resolved, he was supposed to ship out and they didn't realize it until they checked again. And then this warrant came up, and so we have been desperately trying to get this worked out.
All right. Let's go.
Yeah, that when Judge Boyd hears this, she will expedite this, because if he's trying to make something out of his life and he is actively doing something better with his life, Judge Boyd will help you. And this is one of the things that I really admire about her. If she can help somebody who already helps themselves, she will go out of her way to make sure that person gets another chance in life. Hi, Erica. Good to have you here. Good to have you here.
Because he's going to the Marines. Let him go.
Yes, Judge, please.
If you could just have a 2-week reset, because I need some stuff from Ms. Headland to put in a file.
I would have a letter to you and.
Well, is the recruiter here?
I don't have him on the phone. I don't.
Can you zoom in?
Would you be willing to Zoom?
I can see if you could.
Will that help? I'm trying to get him
Okay.
to his military base, because I don't want him, I would always, whenever I was in school, I was like, I want to stay with my class, the milestones with my class. So I'm trying to let him do his milestones. And if you still can't do it, let me know. But I'm trying to.
The other thing too is he did voluntarily went to a rehab last August to September for 5 weeks in Wimberley. I asked him on the way over here, well, how did that go? And he said, well, I was in there with a lot of people that had heroin, cocaine addiction. And he goes, and I was in there for a week. I go, but you see how they got there. And so he recognizes that his grandmother has raised him. His family contacted me when they found out about this. He was, what's it called? MEPS? What's that? MEPS. He was on his way to be sent off. Were you going to San Diego or? And then they ran it just to get him onto the.
You know, sometimes things happen. San Diego, I think they just had a earthquake or something.
Yeah.
So you missed that. Hopefully everybody in San Diego is okay. Then this is what I want y'all to do. And if it works out, it works out. If it doesn't, then it doesn't. I want you to get your recruiter on the phone so that the state can know that you have the recruiter. Because let me just tell you, do I think you're signing up and going to the military? Yes, because your attorneys told me so. But sometimes people will say, "Ooh, I'm going to the military." Then they don't. So get your recruiter on the phone. Let the state be a part of the conversation, and then y'all come back to me and maybe we can take care of this today and you can be off in the military, and I'll send my prayers for you when you go into the military. Okay. All right. So let's do that. And then you guys come back and approach.
Amazing. Thank you.
All right. And remember my drug course that I just gave you.
Thank you.
All right. You're welcome.
Yeah. As I said, if she thinks she can help you, and especially this young kid trying to help himself, she will go out of her way
Don't put it in
to help
We're gonna
you.
see.
And that is so admirable because she didn't need to do any of this. She could have just set a 30-day extension or stay and be done with it. But no, she don't, because she's one of the good ones.
Doing great. Good morning. Hi.
How are you doing?
Oh, I am doing great.
Good.
So I'm glad I think you, Renee, Daryl, and Robert Porter said y'all are going to help with the mock trial. So I'm like, yay.
Yeah, that's tomorrow, right?
That's tomorrow. So the students are going to be here at 8.
At 8?
Yes.
Okay, so I better go rent a suit for tomorrow. Waiting for my clients so we can talk. I'm gonna call the GPS officer. They sent it the record yesterday, so maybe they already have it and they're telling him he's can't do what it goes.
All righty.
Thank you.
All right. You're welcome. Who is zooming in?
Probably off the name. Yes, for this one.
All righty. Who is he here for? All right. Who's by Zoom? Can you unmute? Yes.
Hello.
Yes.
Maybe the victim on the John Hayes case.
All right. Are you on John Hayes case?
No, ma'am. I'm on Paul Bell's case.
Paul Bell?
Yes, ma'am.
All right. Just give us a moment. I'm going to put you back in the waiting room. We're waiting for the attorney.
Okay, thank you.
Welcome.
Yes, Brandon. Yeah, Judge Boyd is very thoughtful, but she does have triggers. One of them we saw yesterday. I cut that out to a separate video when a guy in court, it was revealed that he had both a girlfriend and a wife and kids with both, and he was now off to jail. And yeah, she went on a good rant.
The Wednesday cases have been moved to the afternoon, correct? All right, thank you. All right, thank you. Deputy Laura, I cannot thank you enough for telling me how to do the do not disturb. The spam calls are no longer coming through.
Are you at the book, Judge?
Oh, I'm at the part where they are on the battlefield. The adolescent dragon, they've asked her to leave. She's not leaving, but she's gone back into hiding in the shadows, so nobody can really see her. That's where I am. And I hope nobody dies. Not my favorite people. You know what gets me? They have Liam, right? But then they're bringing Jack back.
I'm about Jack.
And then I don't even know why they continue to try to save Jack when they already knew he had all of those issues and he was betraying everybody. So,
Judge Boyd and her staff is always talking about TV shows and movies.
yes.
It's been resolved, Your Honor.
Okay.
Got the directive and I think they read it.
Okay, awesome. All right. Yeah.
I'll see you in the morning.
All right. Thank you. Have a good one.
On the way to go rent another suit.
Oh, you know what? I need to give you, let me see if I have it. I need to give you the letter that the students wrote on your behalf.
Oh, thank you.
Just give me 1 second. If not, I will print it off again.
If you don't have it, you can give it to me in the morning.
All right, I'll give it to you in the morning and I'll print it off for you, but they really enjoyed you speaking to them.
Well, thank you. Thank you for giving me that
Oh,
opportunity.
wait a minute, here it is.
Okay.
Let me see.
Nice.
I just want to.
Nice.
Yeah.
I'll see you tomorrow.
All right, bye-bye.
David Escobedo? Yeah.
Yeah, I'm not a fan of Paisley either. I used to have ties
All right,
like that
David
in
Escobedo?
the 90s. And they were ugly back then too.
All right, if you'll come forward. No, where is he?
He's here. I just told him to sit down before you called.
Okay.
Morning, man.
Good morning. So where are we on discovery?
I have requested blood discovery. The state said they're going to be requesting it from GPS labs. And we'll see where we go from there. I filed a 3914 request. The state asked if I filed a motion. I said, I believe it's still discoverable under 3914. He agreed, but he wasn't sure whether or not they would produce it.
All right, so let me just tell everybody this. When I was in law school, my trial ad professor was Judge Bart. You know, they called him the smiling assassin.
No, I didn't know
Because,
that.
well, they call him the smiling assassin because he would smile at you, dress you down, and you didn't know you had been dressed down until you go back to your seat. And you're like, because I saw him tell somebody, your use of demonstrative evidence was ineffective at best. And you know, he's smiling at you when you say it. So you walk away and you're like, oh, wow, wait a minute, what? So this is what he would always tell us. He said, even though there is something that you know you're entitled to, if somebody is saying, hey, just file a motion because I need it, he said, if it's no big deal, just, file it. So I appreciate you for saying, you know what, I'm entitled to it. I know I'm entitled to it, but I'm just going to file it because it'll probably make his job easier, getting it to DPS and everything. So I appreciate that. What I'm going to do is I'm going to give you a 45-day reset because usually it takes a little bit of while for the blood discovery. It may or may not be in by that time. I don't know, but we shall see. Ms. Ferguson, I need a 45-day reset.
We're gonna get resolved because the thinking business.
All right. So we're going to come back on May 29th.
Appreciate you.
All right. Thank you. Once you sign the reset form, you're excused, and thank you for coming dressed appropriately for court.
Yes, ma'am.
Thank you.
Appreciate you, buddy.
$4.
Norma, you know what I gave up for Lent? Michelle, what do you think I gave up for Lent? Alcohol. I think it does count
Hey,
because
MD
even though I
Law.
don't drink, I could.
Good to
So
have
I
you
just
here.
doubled down on it and said, I'm not going to do it.
Oh, MG Law, have you seen? The Court TV has gotten some trial exhibits from the Delphi trial, including the toolmark experts, what she deemed made Rick Allen's gun a match to the cycle cartridge. I've been looking at them while I've been streaming here. Oh, I have words. Oh, I have words. But MG Law, go check. Let's see here. Wait a minute. Here is the link to the Court TV because Court TV are publishing what they got from the court, and it's nowhere near everything, but we are starting to get the evidence out now, and but well, you might. My conclusion about the toolmark evidence might not come as a complete surprise to anybody, but please, folks, go check for yourselves before I give you a more detailed opinion in a later stream or video.
Yeah.
Exactly right.
Well, a lot of peer pressure out there.
That'd be like if I said I don't have giving up cigarettes now, smoke.
But no, because you know what? There's a lot of peer pressure. People tell me, Judge, the reason why you say alcohol doesn't taste good is because nobody's giving you the right alcohol. So there's that peer pressure out there. Oh, on that other case, were you able to talk to anybody, Megan? Okay, all right, thanks. Paul Bell.
No, Pastor.
Okay. Oh, no, Paul Bell is here.
We're here, Your Honor.
Okay. All right, you have your black umbrella. Are you anticipating something?
There was a little drizzle on the way in, Your Honor, and I hate to be the attorney walking to his car looking like a fool.
Yeah. Or somebody taking your umbrella.
That's
Keep an eye on it.
that's happened at least twice in this courthouse.
Okay, let me see. This is.
Yeah, I know,
All right, Ms.
Brandon.
Abrams.
Your gin drinks
Mr.
are
Bell,
a
they're
one
asking for
ingredient.
early termination. So when you get a chance, if you can look through it, and I'm going to take some testimony and see what's going on. All right, court is calling 2024 CR 0058, State versus Paul Bell. Can our parties announce for the record for the state?
Rick Pena for the state of Texas.
Defense?
Austin Hagee representing Mr. Bell.
And are you Mr. Bell? All right, so you were placed on 2 years deferred adjudication on April 1st, 2025 for assault, family, choking, strangulation. Your attorney has filed a motion asking that your probation be terminated. And so, as you all know, in cases involving where there are victims complainants, I always want input from the complainant as well. And of course, it goes without saying, if probation is not in agreement, then for a reason that the court deems appropriate, then it will not be granted. For example, if you've had prior violations while you've been on probation, those type of things. You understand?
Yes, ma'am.
All right, so Mr. Hagee, you may proceed.
At this point in time, I would call Kim Bell.
All right. If you can unmute, please. And do you have any objection to this witness being by Zoom, State?
No objection from the state.
All right, Ms. Bell, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kim Lisa Bell.
All right, and we have standing in for the state.
Ashley Jones for the record.
All right, defense, you may proceed with your witness.
Hi, Kim. How long have you known Mr. Bell?
About over 32 years.
And how long have you been married to him?
32 years.
And you all have had a relationship throughout this case.
Oh, most definitely.
Yeah, y'all been together throughout the case, and y'all are together at this moment now.
Yes,
And y'all still live together right now.
that's correct.
Okay. Are you in support of him being early terminated from probation?
100%.
And you would like for the state to allow him to do that?
Yes,
Is there anything else you want to share with the court?
I do actually.
Okay, go ahead.
I feel that the time that Paul has been on probation, he has done what he had to do through the courts. He's done what the DA and what the judge has requested him to do. I feel that Paul has been extremely remorseful for what happened that evening. We've never had an incident since. Everything's been great between him and I and our marriage and our family. We're still together, and we're planning to still spend another 32 years together.
Thank you very much, Kim.
You're welcome.
Any questions?
Just briefly, Your Honor. Hi, Ms. Bell. Can you hear me okay?
Yes.
Okay, my name's Ashley Jones. And I just wanted to ask you a couple questions. You said just now that, while he's been on probation, he's been good and he's done everything that the court has asked. Do you think being on probation has helped facilitate that, his behavior?
I just think Paul as a person has helped facilitate that behavior. I think that he realized that he did something wrong that evening, and I think that he has been steadfast trying to rectify that situation, not only for myself and for himself and us as a couple, but also for our family.
Okay. And you can understand how, at least from the state's perspective, that when somebody hurts another individual, we have to look out for the safety of that individual, right?
Of course.
Okay. No further questions, Your Honor.
Any follow-up? Any objections to the court asking questions? All right. So I have a few questions for you. The first one is, other than this incident, have there been any prior issues or arguments that turned physical with Mr. Bell?
Your Honor, are you asking me?
Yes.
Oh, I'm sorry. I thought you were asking Mr. Hagee.
No, I'm asking you.
Okay. No.
So what caused this to happen? Because it would seem to the court that normally things don't escalate this way. So why did it escalate to a choking?
I can't answer that. He's never done this to me before.
All right. And did you all complete couples counseling? Because my understanding that was what you requested, because normally I can't force people who are not under my jurisdiction to do counseling, but as a part of his conditions of probation, because the state didn't object to you having contact and you wanted to have contact with him, you wanted the court to order couples counseling. So was that completed?
No, we didn't complete the counseling due to the fact that we were seeing a pastor, and the pastor got extremely ill, and he just stopped seeing a lot of his clients. And then the church called us and said that he wasn't seeing clients anymore.
All right. And how long have you been married to Mr. Bell?
In February 9th will be 32 years.
All right. Any other questions?
Me?
No, I'm asking the state, the attorneys if they have any other questions.
Okay.
Just briefly. Ms. Bell, you understand about the cycle of violence?
Yes.
Okay, how there's a blow up and then everything is good for a period of time until there's another blow up?
Yes.
And you can understand how the state, at least in this case, is worried about that second blow up?
Yes.
No further questions.
All right.
I do have a question.
Yes.
Your Honor. Mr. Bell's completed several courses as a part of his probation. Kim, is that right?
Yes.
Oh, you're asking
It's
me?
not for you, it's for her.
Yeah, she's
Oh.
the witness right now. Yeah.
I'm so sorry, Your Honor. I'm confused because I'm not in the courtroom, so I don't see I don't see your face. I don't know who you're talking to. So.
All right. So you're still on the witness stand.
Yes.
So all questions that are being directed towards you.
Okay.
If there are no more questions directed towards you, I will let you know. So
Thank
just
you.
assume that all of the questions are being asked of you. You may
Okay.
proceed.
Thank you.
This is Austin. I'm asking you a question right now. The question I have is, do you know if Paul completed any courses during his probation?
From I understand, he completed all the courses that were required that he needed to be completed by the court.
And you said you saw a positive change in him throughout the course of his probation.
Yes.
That's it.
All right. What changes did you see with regards to his ability to parent?
I feel like he listens more. He's more understanding. He's tries to create a better environment in regards to making Nadia feel that she can go up to him and talk to him about whatever issues that she's having. He's more open and receptive in regards to with like certain issues when it comes to, let's just say an example, like her having a little boyfriend, even though she's 11, but still we're trying to, finagle the parenting role like any parent would.
And since he's done batterers intervention classes, how has his communication with you changed?
Oh, he's much better. I feel like he tries to do the more listening and talking situation instead of trying to just talk over me.
All right, any further questions?
Not from the state, Your Honor.
Nothing from the defense, Your
All right, there are no more questions for you. Defense, any other witnesses?
Honor. I will call him Paul Bell.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
You can lower your hand, state your name for the record.
Paul Bell.
All right, defense, you may proceed.
Mr. Bell, we're applying for early termination of your community supervision. You understand why we're here today?
Yes,
You completed all the requirements of your community supervision.
yes,
You've reported every time you've been asked to report.
yes,
Have you had any violations?
no,
Have you failed any drug tests?
no,
Any alcohol tests?
no,
Completed all your coursework?
yes,
Have you learned a lesson from this?
absolutely,
Do you ever want to see the inside of a courtroom again?
no.
Okay. That's it. I've asked the witness, Your Honor.
Any questions?
Yes. Mr. Bell,
I'm sorry, I can only hear on the left side.
that's okay. Hi, I'm Ashley Jones. We haven't met before, but I just have a couple questions for you.
Oh, so this is what we can do, since you can only hear on that side. State if you'll just talk to him from this side, because I need to see his face.
I just got over a bad ear infection, so I can only hear on my left side.
No problem.
So just a couple questions I have for you. You understand what you did was wrong,
Yes,
and you were sentenced by this court to a term of probation.
yes,
And although you've completed everything on your probation, you can understand how the state is still concerned for the safety of the victim.
yes,
And one way to alleviate that concern from the state is to keep monitoring our defendants who are on probation. Would you agree with me?
yes.
No further questions, Your Honor.
All right, I have a few questions. Oh, and you all can switch back.
Thank you, Judge.
You had to take the batterers intervention program.
Yes.
What did you learn?
Well, we learned quite a bit. It was a very group-oriented type interaction. The facilitator for the course was very interactive.
No, but what have you personally learned?
Personally learned just how to be a better person, be a better man, a better husband.
What does that mean?
I guess, for myself in the past, like my wife mentioned, a lot of times that, I would want to speak first and not listen more. I think it allowed me to kind of just take that approach of being more of an active listener and to, have a little more compassion with my approach and with others' approach to me, to understand that, empathy can go a long way, especially when having a relationship with anybody.
All right, and what did you learn from parenting classes?
Well, just, children that, and we have two older children, we have a 31-year-old and a 28-year-old, and now we have an 11-year-old, actually 12. She just turned 12. That going through the changes in their lives, for myself, it's just understanding that and being a little more, I guess, receptive to the changes that they're going through. And for my daughter, Nadia in particular, I have a chance with her more than I had with my other two because of my 27 years in the military did not allow me to be at home as often. So now with my 12-year-old, I have a chance to kind of redo some of those things or, make things better for myself and for my family that I couldn't do for my older two.
All right, any other questions?
Not from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, any other witnesses?
No witnesses from the defense, Your Honor.
State, any other witnesses?
No witnesses from the state, Your Honor.
All right, probation, if I could have some input.
Judge, Mr. Bell has completed his VIP course. He's completed his parenting class, his mental health evaluation. He's submitted all negative UAs. All of his fees are paid off. He reports as he needs to. He's been, from the notes, a very good probationer, Judge.
And is probation in favor of early termination?
Yes, Judge.
Okay. All right, this is what the court is going to do. If there are no issues, the court will grant early termination, but that early termination will not be signed or take place until May 8th, because we have something coming up in San Antonio where people sometimes don't behave as they should, called Fiesta. So early termination, if there are no issues, will be granted on May 8th.
Thank you.
Right.
May 8th, be signed. Yeah, we still got a couple more weeks. Yeah.
All right, is there anything else?
Nothing from the defense, Your Honor.
Not from the state.
All right, thank you. Just counsel, you can just come by yourself if you want on May 8th and it will be signed.
I'll come early. Thank you.
Thank you.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome. Have a good day.
You too, ma'am. Bye-bye.
Bye-bye. No, Norma, you don't need to set it. Defense should bring it. You're welcome.
All right, that is one guy who is no longer on probation. Good luck to him. Now, do I believe that only once in 32 years an argument turned physical. It might be. I don't. The few cases I've been in my line of law that included some physical alterations between spouses, rarely has it been a one occurrence. I don't know. I haven't actually seen one
All right, Ms. Headland, do you have an
one-time
update?
occurrence of this.
Ah, oh, who is it?
But that's just me. I don't handle
It's Flores.
very many
come
of
forward.
those.
Sergeant Flores? Oh, if you can unmute for me, please. Hello, are you Sergeant Flores?
Good morning, ma'am. I am.
All right, so we're just here because Sebastian Gonzalez is stating that he is enlisting in the Marines. Is that true?
That is correct. He started the process already. But
All right, so
yeah,
my
so
understanding is the only thing that is holding him back is this case. Is that correct?
that is correct.
I didn't hear you.
Yes, ma'am, that's correct.
All right, so state. Yeah, well. All right, so here's what I'm going to do. I'm going to make sure this case is taken care of. It's going to be taken care of today so that he can complete his process with. I expect you all, because he's 19, you all had better take care of him.
Yes, ma'am, we will.
Now, I know you all say that, but I've had people in the military, a lot of my family members, and then once you sign on the dotted line, your life is not your own. But make sure you get everything in writing. This is the contract attorney and me coming out. All right, is there anything else you'll need from him?
No, ma'am, just for him to continue being and doing what he's been doing so far. So same motivation, same enthusiasm, same attitude.
All right, well, I can tell you one thing, you're gonna be in shape physically. So there you go. Maybe I should, do you have a program for me where I can just sign up just to get in shape? I really don't want to do it, but I'm just, looking to get in shape physically.
You're more than welcome to come to the office. We have a small gym and we can create a workout plan for you.
He says that, and where are you located? See, I'm serious. See, he laughs now. He's like, I don't know about that.
That's how this knows. He knows where we're located.
She's not gonna push back from the table. All right. So we'll make sure that he has any dismissal form that you need so that he can take that to you. All right.
Yes, ma'am. Thank you.
All right. Thank you so much for zooming in. I really appreciate it. And thank you guys for your service.
Thank you, ma'am.
You have somebody hiding in the back over your shoulder. Hi.
Thank you.
All right. Bye, guys. Thank you.
Thank you.
Thank you, Flores. Thank you.
Thank you.
No worries.
Yeah, it
All
seems
right. Good
like
luck to you.
Recruiting away.
Yes. Be safe. Okay. And I'll always keep you in my prayers. I always remember, people think I don't, but I remember everybody that comes before me. So be safe out there. Okay. All right. They're going to give me the reset. They're going to give me the dismissal. I'm going to sign it. And
Get copies.
yes. All right. Thank you.
Thank you so much.
All right. You're welcome.
Yeah. Again, Judge Boyd did not have to do this. She could have just stayed for 30 days and be done with it. But no, if she believes that Mr. Bell trying to help himself, she will go out of her way to make sure that he will be able to help himself. So, yeah, if this kid who apparently did some stupid things in his youth, well, he's still a kid, but now he is joining the Marines, and they accepted him, which means he had to go through a lot of evaluations. So I assume he is going to do decently, and because if he doesn't, he will be in front of Judge Boyd again, and yeah, he does not want to do that. So good luck to you, Mr. Bell. Good luck to you.
Yes.
Rockport, the smaller.
Yeah.
Be exciting. My folks are still there.
Okay.
Get to have
Yes.
that tomorrow.
Yeah, that's fine.
Thank you, Judge.
All right. You're welcome. Have a good one. Who is here on Emilio Lopez?
Morning, Your Honor.
Good morning. How are you doing?
Very good.
Hello, Mr. Lopez. Thank you for dressing appropriately for court. Counsel, where are we on discovery?
Judge, they have provided me discovery. I am in the presence of reviewing it. It's his first setting. I also spoke to the state. They need to confer with the victim in the case prior to making me an offer. And then we should be able to sign a discovery acknowledgement at the next setting, Your Honor.
All right.
Yes, I was just about, this one signed CCD and it was just brought to our attention this morning. It should be finished on, so I need to have contact with the victim so we can make the appropriate offer.
All right. Ms. Ferguson, can you put this on May 20th? All right, we're going to come back on May 20th. And at that time, state an offer will be due.
Yes, that's fine.
All right. Once you sign the reset form, you excuse. Thank you for dressing appropriately for court.
I just real quick, I just want to verify the date because I think I'm okay
Okay.
on that date, but I have a jury trial that week. No, it's on the 22nd. I'm okay.
All right. Thank
24th.
you. All right. Have a good one. I just have a seat and they'll bring the reset form to you. Who's here on Victoria Villarreal? Hello. How are you doing this morning? Oh, yes. All right, counsel, are you ready to proceed on the motion to revoke or no?
Yes, Your Honor, ready to proceed this morning.
All right, can I have a file stamp for a motion to revoke, please? Thank you. Did you do a trial court search?
In my haste, I may have forgotten that.
Okay, you may need to get it from the clerk.
Right here, Judge. I can sign right now, and I have my client sign as well. I already explained everything. Okay. Send it to the court, Your Honor.
Yes, thank you. Court is calling 2020 CR 2212 State versus Victoria Castro Villarreal. Can I have parties announced?
Andrew Harris Edelman for the state.
Renee Munoz on behalf of the defendant.
And are you Ms. Villarreal? Yes. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Victoria Castro Villarreal who was placed on deferred adjudication in 2020 CR 2212 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on July 2nd, 2020 for a term of 4 years? Is that you? All right, state.
In Bear and or DeWitt County, Texas, the defendant Victoria Castro Villarreal did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, and November 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations, Judge.
No objection to the state waiving the remaining conditions.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? All right, you're whispering.
Yes, ma'am.
Court is finding violation of condition number 5 true. Is there a proposed agreement?
I believe so, to adjudicate and sentence to 2 years TDC.
That is understanding of the recommendation to the court, Your Honor.
What has she done on probation?
She has not reoffended, not picked up any new offenses ever since this possession charge, Judge. In relation to her criminal history, this possession charge is the only thing she ever had. She may have bit off more than she can do in terms of the supervision. There was some issues with family that caused her to be somewhat homeless. Mom losing the apartment that they were in, not affording her the opportunity to check in, and she was scared at that moment and just kind of just didn't check in because she thought she can get picked up at that point in time. Shortly after the issues with the family home, so she just didn't check in, Judge. But in reference to this charge and to the decision before the court, we asked the court to look at the charge which is on probation for. She was on probation for, which is possession of controlled substance. It's a nonviolent offense. There are no victims other than the state of Texas and her doing this to herself in terms of the drug usage and the wear and tear on her body, Judge. She has 4 granddaughters. She wants to be there for them, to look over them. She has explained that she currently does not suffer from using substances in terms of addictions, but at the time of this offense, she was dealing with that. I went back to the original case and looked at the circumstances of that case. And it seems like the officer had seen a straw pop out of her pocket and there was some residue on it, which led them to uncovering some methamphetamine in her purse. Although it is classified as second-degree offense, Judge, it was more or less around the 4-gram range. I think it was like 4.3 grams. So I know that's a large range, the 4,200, but we're in the bottom range of that, Judge. So I went over the options with my clients, notified her that staying on probation was going to be a stretch because of the amount of time that she had not checked in. But we're just asking for the honorable court to sentence her in reference to the offense, which is the possession charge. We know that she didn't do much of anything on probation, but she did stay out of trouble, did not pick up any new offenses ever since this 2020 offense, Judge. So this would be the first felony conviction for her and the first time for her going into prison. So being that that's the case in the circumstances, Your Honor, we're asking that the court honorably enter into the 2-year recommendation. I did notify my client that the recommendation is not binding on the court, but I told her I would offer this mitigation to the court so we can get a better look that she's not a career criminal or threat to the community or society.
All right, I have some questions for you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. State your name for the record.
Right, that's what it is.
All right, so did you complete intensive outpatient treatment with probation?
That,
That's outpatient.
no,
Did you provide proof of employment?
no, I didn't do something, I'm working.
I'm sorry?
We went, because my mom had to get kicked out of her house, so we had to move to, Clark County.
All right, so how old are you? All right, so you're 40. You're dependent on your mom to support you, and
That's how I
because,
first got out. I was gonna try to get back on my feet.
okay.
I did, they didn't get on, like the RV, the property, have like an RV.
All right, so let me just tell you my issues with you. My issues are that we were here previously before for your not reporting. And you continue to not report. Reporting is the easiest thing to do on probation. All you have to do is report, and you didn't. That's a problem. And I don't know if you're clean or not clean.
I'm not taking on my granddaughter, because my son, I lost my kid's GPS for my two, I got my children back to age out.
Mhm.
I'm not gonna leave my grandkids on.
Well, here's the thing. You're saying you're not going to lose your grandchildren. You are. You're about to go to prison.
Now I have a choice, but I have no dogs.
I think the issue, Judge, if I may interject, and I apologize to the court for this, is that the time she was dealing with these issues of non-reporting, she was also seemingly dealing with her addiction issues. And I just feel that maybe after SATIF, which she did complete, Judge, that maybe some more intensive care would have been in line, but I feel like she was still struggling with those issues, which made reporting a little difficult for her, and she probably was fearful. But I've explained to her sometimes, a lot of the times we have to face our fears, because if not, they're eventually going to catch up with us, and it's going to be much more detrimental to our future than just facing up to the fear. And she's taking responsibility and accountability, Judge. She knows what she did was not correct. We're not asking that she be continue on probation. We understand the court wants to adjudicate her, but we're asking that the term of years is on the lower end, as she's first time going to prison, first time being a convicted felon, and not reoffending, Judge.
Probation, has she done anything on probation?
Judge, she completed 119 days in SATIF.
She was working on it, Judge.
All right, this is what the court is going to do. The court is going to find you guilty. The court will revoke. The court will sentence you to 5 years in the prison, give you credit for any time served, request a therapeutic community. There's a $1,000 fine, time and money to run concurrent. There's to be no unsupervised contact with minors, credit for any time served in SATA. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Obviously, you have a drug problem. When you are released from prison, if you cannot find a place to go, if I'm still here, you come back here, I'll pick up the phone, call, so you can get in a place so you can maintain your sobriety. Because when you don't, one or two things going to end up happening. Either you're going to go down this line where you're going to constantly be in and out of jail, in and out of prison, or either you're going to get some bad drugs and somebody's going to have to identify your body. And usually the person they have identify the body is a family member. So it's got maybe your mom, maybe your children, maybe your grandchildren. You understand? All right, good luck to you.
May we go on the record briefly
Yes.
so I can state the SATIF dates?
Yes.
As per the probation court summary and also verification of my client, that she completed SATIF for the dates of August 20th, 2021 through December 17th of 2021. And council just wanted to get that on the record.
All right, and if you'll just make sure that the clerks have that time.
Definitely will, Your Honor.
All right, thank you.
Yeah. She went into the FO of the FAFO.
All right, who's here on Johnny De La Rosa?
I am Judge. It's a bond reduction. I just have one witness. I've already conferred with the state.
All right. Come forward.
He's in the custody jail.
Come down. And I see you already have your jury trial set.
Yes, ma'am.
Court is calling 2024 CR 008420, State versus Johnny De La Rosa. If I can have parties announced.
Megan Galloway for the state.
Robert Mauer for defendant, Judge. And I have one witness that's going to testify, his mother. So she's. I'll call you up.
People just moving around the courtroom. You know, if people don't know, they're forgiven, but once you know. All right. All right, defense has filed a motion for a bond reduction. State, have you had a chance to review the motion?
Yes, Judge.
Do you all have an agreement or no?
No, Judge.
All right, then defense, you may proceed. Do you have any witnesses?
I do, Judge. I'd like to call Patricia De La Rosa.
All right, Ms. De La Rosa, if you'll come forward. Can you raise, just one moment. I'm on allergy medicines and it's drying me out a lot. All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Patricia De La Rosa. Member Steve?
Yes.
Ma'am, you understand we're here because we filed a motion requesting that the court reduce your son's bond from its current amount of $75,000.
Yes.
Okay, and have you spoken with any bondsman about what it would cost you to bond your son out based upon this amount?
Yes.
And who have you spoken to?
His name is, De La Garza.
Okay, and how much did Mr. De La Garza quote you to bond Johnny out on the $75,000 bond?
3,000.
Okay, is that as a deposit? And the rest of it, was there more payments required after that?
Yes,
And do you have the financial ability to make that bond?
I have 1,200.
Okay, so you can't make the $3,000 bond. Are you asking the court to reduce the bond to $50,000?
Yes, sir.
And do you own any real estate free and clear that you could put up for the bond?
No,
Do you own any, do you have any stocks or bonds that you could put up,
no, sir.
or any other property that you could put up to bond him out?
No, sir.
So if the only means you have of bonding him out would be if the court reduced the bond down to $50,000.
Yes,
Can you understand it? If the court did that, he would still have a GPS condition and other conditions imposed by the court.
yes.
I pass the witness.
All right, state.
Ms. De La Rosa, what do you do for work?
I'm a caregiver.
Okay. And as far as your payment goes, I mean, about how much money do you need per week?
A week.
Or monthly, whatever's easier for you.
Monthly, it's yes, it would be about 1,200 a month.
And so as a caregiver, you're going into people's homes and providing care for them?
Yes,
Okay, and about how many clients do you see?
during the week one and on the weekend one.
Okay. And do you work for like a company?
Yes.
Is that, okay. Is there the ability for you to pick up more clients or no?
I just picked up one for the weekend.
Oh, okay. And as far as Mr. De La Rosa goes, or the person that you spoke to, Mr. De La Garza, was that an attorney that was going to help you with the bond?
No, but he owns one. I don't know if he owns, but
He works at a bail bond company. Okay. And you just reached out to him, or did you reach out to any other bonding company?
I reached out to another one and I have to get back with him.
Okay. And as far as, I guess, Mr. De La Rosa, have you ever had to bond him out of jail before?
Yes, I have.
Do you remember, was that in 2022?
I think so.
Okay. All right, pass the witness here.
I'm nothing further.
All right, thank you so much
Thank
for
you, ma'am.
coming in to testify. All right, any other witnesses?
No, Judge, just argument.
All right, so what is,
Just, sorry, before-
Yes.
I wanted to just offer the police report as states one for the purpose.
I have no objection.
all right, and your client can come back. And the court is reviewing State's Exhibit number 1. Thank you. All right, court will hear argument.
Judge, my client's bond is currently set at $75,000. It's beyond his family's financial ability to make the bond. I believe with the current conditions already set of GPS, I think with full house arrest, a $50,000 bond would be reasonable in light of those circumstances. His family could afford to post that bond, and the GPS would ensure any concerns about safety of the community.
All right, state.
Judge, just based on what was provided in State's Exhibit number 1, we're asking the bond to stay at 75,000. And just based on Exhibit number 1, I have concerns about the safety of the victim. Should Mr. Del Rosa be released?
All right, I've heard argument. I reviewed all evidence in this case that was submitted to the court. The motion for bond reduction is denied.
Thank you, Judge.
You're welcome. Yes. Oh, I'm so sorry. Can I have that motion?
You notice the difference between how she acts with, for instance, Mr. Bell earlier and
Victor
this
Anthony
one?
Fernandez.
She has to believe that you are trying to better yourself. Because if she doesn't believe you, you are not getting easements.
All right, so we have an issue, and it's with regards to the paying of restitution. So you're supposed to be making a minimum $800 per month payment, and you have not been doing that.
I've been making like $200, $300.
Yeah, you're supposed to be, I mean, I know that's what you've been making, but you're supposed to be making $800 payments.
I'm having hardship, a financial hardship.
What is the financial hardship?
I went on Social Security. I'm 64. I'm gonna be 65 in July.
Mhm.
They reduced my Social Security by $1,000 for a case in California that I need to go to California to close. Because I contacted them in 2021. They said all I had to do is go to California and they'll close the case. They say that I owe $117,000. They attached that case to Texas SSI, and they're taking $1,000 after they for it.
All right, so here's the thing. This person is owed $248,000. They want their money. And I understand that people have hardships and everything that's going on, but they want their money. They're
But
entitled to
there's
their
like
money.
4 different things that happen.
No, I understand, but you're gonna have to figure out a way.
Yes.
The minimum payments is supposed to be $800. And the complainant is saying that they've been receiving payments sporadically. It's not consistent. So
I paid $17,000.
$17,000 or $248,000. And I am sure that this person's life will never be the same again because of the nature of these charges. So she
I'm
wants
still
to be
waiting for the
paid.
company to go
Mhm.
start the manufacturing. They moved back to Tucson, Arizona. They have new investors, and the company's supposed to start manufacturing. And once they go public with the stocks, then I'll receive cash.
When is this going to be done?
We think in about 2 months, Judge, and the company's name is Avimech, Avimech. They build helicopters. He is a shareholder of the company, he and his
I'm on
partner.
the board of directors.
So what they've been trying to do is take the company public. They had an investor, that investor got audited, so that kind of slowed down the
Yeah,
process. So they
messed
now
up
have a
everything.
new investor and they should go public. They moved the company physically from San Antonio to Tucson. And we believe about 2 months, Judge.
To start manufacturing.
All right, this is coming back on June 26th, and you had better make some payments.
Yes,
Judge.
All right, Ms. Ferguson, this case is coming back on June 26th. Bashan, this case is coming back on June 26th to see where he is on making payments.
Maybe excuse, Your Honor.
Yes,
Thank you, Your Honor.
you're welcome.
I'm not entirely sure I would trust that guy in building anything. Just saying.
Everyone, the
Just
court is
saying.
recessing at 11. I've informed everybody that before because we're starting back up with jury trial at 12:30 and the staff will need a lunch break. So anything else that is not taken care of, you're coming back on Thursday.
Okay, jury trial. I suppose they are talking about the McIntyre case. and we will finally find out the sentencing. Ooh, I forgot we are a bit behind, so we can actually go directly to that live. So we can actually find out what the sentencing of Mr. McIntyre will be. Still muted. Still muted. Yeah, it's in the hands of the jury what sentencing they and yeah, nothing yet. Nothing yet. So let's get back to this one.
John Hayes? All right, so he entered a plea of true to 25, correct? And we're waiting for the complainant to appear. And she is here. All right, I believe this is family violence.
And I have a manager. I'm trying to get Ms. Jones answers for case.
Okay.
Thank you.
Hello, just give us one moment. Are you the complainant, Samantha Hayes?
Samantha Rubio.
Samantha Rubio, okay.
Yes, ma'am.
We'll need that corrected. All right, the court is calling 2023 CR 3545 State versus John Thomas Hayes. Can I have parties announced for the record?
Ashley Jones for the state.
For the defendant, John Thomas Hayes, Your Honor.
And are you Mr. Hayes? All right, you entered a plea of true to violation of condition number 25, which is contacting the complainant, even though the court ordered no contact. And the court asked for this case to be recalled because the court was informed that the complainant was contacting the defendant, but then there were other issues where people were saying that she only started contacting him after he contacted her. So I want all of this cleared up so that I can make an informed decision on whether to continue him or not continue him. My understanding is that the complainant is here. She's present by Zoom. Can you raise your right hand for me, please?
Yes,
Do you
ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Samantha Rubio.
And were you previously Samantha Hayes?
Yes, ma'am.
All right, any objection to the witness appearing by Zoom, state or the defense?
Not from the state, Your Honor.
No objection for the defendant, Your Honor.
Any questions for the witness?
Not from the state unless you wanted the state to ask,
Yes, if y'all have, because I'm assuming you all are requesting revocation.
actually, Your Honor, I think we were requesting, the,
Continue.
yes, with the mental health, treatment that the probation was recommending.
All right, then I have a question. All right, so, Ms. Rubio, you understand that I ordered that you're not, that the defendant, Mr. Hayes, is not to have any contact with you?
As of April 8th, yes.
No, I mean, this has been in effect since November 4th, 2024.
No, I was not aware. I was not at the hearing. I was only told on April 8th.
So you're telling me up until April 8th, you didn't know you were not supposed to have contact with him? Well,
I
I'm
knew
sorry,
there was-
I have no jurisdiction over you, but you're telling me that in April 8th, you just discovered that he's not supposed to have contact with you?
Yes, because I asked I think it was Marina when I spoke to her, what the conditions were. I was just aware that he was going to a health facility and he had 6 years probation because every time she contacted me, I was at work.
No, well, see, here's my thing. You're saying that you don't know that he's not supposed to have contact with you. And then I have a motion to revoke because he's constantly contacting you.
Again, on April 8th, when she told me there was a no contact because I asked what the conditions were, that's when I told her that he had contacted me.
All right, so here's the thing. You know you're not supposed to have contact with her. I don't know why you should remain on probation because my orders are very simple. My orders are no contact. Is there something somebody can explain to me then? Why doesn't he know that he's not supposed to have contact with her? Because it clearly states on his conditions, he's to have no contact with her. So whether she's contacting him or not, he knows he's not supposed to have contact with her.
There is a child
Oh,
involved, Your Honor. There's a 3-year-old child involved that they have a child together.
I understand that, but I told him no contact. And I always tell people when you have a child, guess what? You're going to have to go through a third party because we're here for a violation of bond protective order assault. So because you're here for a violation of bond or protective order, you know what that means? There have been previous orders that are in place that you have violated where a court has told you you're not to have contact with her. If there were not any previous violations, guess what? You wouldn't be in felony court for violation of bond protective order. So I don't know if he's appropriate to be continued. I know the state is saying we want him continued. Probation may be saying you want him continued, but it appears that he doesn't understand what no contact means.
Your Honor, I want the court to consider that the fact that Mr. Hayes has mental health issues. He has initially, I was not the attorney at the time, but initially apparently he was deemed incompetent, and so he had to regain competency. And in that time period, apparently he has been in custody 782 days, almost 2 years, more than 2 years. So if the court is going to revoke Mr. Hayes, I just want the court to consider that and consider the record that he shows that he has mental health issues.
Okay, because I just don't, nobody has given me any reason why he shouldn't be revoked because he's here for a violation of protective order, which means that a protective order has been placed and he's continued to violate it. That's why we're here. Otherwise, you wouldn't be in felony court. When a court orders no contact, that's what it means. This whole thing, the complainant is saying she didn't know she wasn't supposed to have contact. She did. And let me just tell you why I believe she did.
Can I say something?
No, you cannot. Let me tell you why I believe she knew she was not supposed to have contact. Because there's an order in place before they even got to this court that says he's not supposed to have any contact. So that means somebody had to go to court. And usually when they have on the civil side, these orders about no contact, the complainant is usually there and there's usually a representative for complainant. Normally, the person who has the protective order against them, usually they're not there, or either they waive or parties agree, you know what, we're just not going to have any contact with each other. So everybody knew there was supposed to be no contact. So when people come here saying they didn't know, they knew, because that's why we're here in the first place, because you previously violated a protective order. So there we are.
My understanding of
Why
protective.
shouldn't I revoke him?
And Your Honor, if the state could just speak in, speaking with the complainant, I'm happy to ask the complainant now since I have her. But in speaking with the complainant, we did discuss the options involving this motion to revoke probation. My understanding from our conversation was that she wanted him on supervision as long as possible and to get treatment rather than just go to prison with no treatment, him get out and then still.
Well, here's the thing. He can get treatment as prison. This is what I don't think people understand. What I've learned from these cases that involve violence, and I understand the circle of violence, I understand all of that. 9 times out of 10, from my experience as a prosecutor and a defense attorney, you know what people want? They want to remain in relationships with their partner who's abusive, right? Because they love them, but they want the court to make them behave. I can't make people be good boyfriends. I can't make people be good girlfriends. I can't do that. And I cannot keep him on probation for the rest of his life so that he can be a decent father or a decent boyfriend. Can't do it. He has been violating my order. And when you look at the motion to revoke with him contacting her, it's March 20th, March 16th, February 14th, February 4th, February 2nd, January 25th, January 21st, January 19th, January 18th, January 12th, January 11th. Telephone, mail, or in person. I can't make people be good partners for people. I don't have that authority. Either people want to be a good partner or they don't. I know that's what people would love, for this to be a family unit, for he to be in your life, for y'all to be a happy, loving family, and for him to be a good father. But I don't have any control over that. I don't think he's a good candidate. I don't know how many times I have to tell. That's the number one thing. Report, no contact. Whether she knew it or not, which I think she knew, he's not supposed to have contact. And if I were to continue him, you know what's going to end up happening? He's going to get released. They're going to have contact. She going to call him. Then he's going to come to me. And whoever's attorney is going to say, well, she's the one who contacted him. And this relationship is not going to work. So I don't think he should be continued. Is there a trial court certification?
Yes, we did, sign one.
All right, let me
First
see.
time.
Do you all want to agree on a time?
Your Honor, if we can have just a moment to confer.
Sure.
Thank you, Judge.
Yeah. FAFO. Fuck around, find out. Even if he doesn't have all tools in the shed, no contact is very easy to understand, especially as it seems it has been repeated to
All right,
him
thank you, Ms. Rubio.
quite
Thank you.
often.
Matthew Insariego. Come forward.
Morning, Judge.
Good morning. So where are we on discovery?
It's a first setting case, Judge. I need to get discovery. I review discovery from the city.
Okay. What's up, Doc?
Good morning.
Good morning. I'm doing great. So does the state have any discovery for you or no?
I'm not certain, Judge. I just spoke with them this morning. There's also something else they're looking into, a potential separate case that hasn't been filed.
And what is the alleged separate case?
I confirmed with Mr. Woodard this morning, and the police report that we received for the theft of vehicle that has been indicted, the defendant has been listed as a suspect in an ancillary case. And so I wanted to reach out to the police department to see if they'd be submitting that case to our office. That way we could resolve everything together. So I don't have the discovery on that other case where he's allegedly listed as a suspect.
Okay, all right. So we'll recall this back for discovery for May 20th. Ms. Ferguson, if you can put this for May 20th for discovery.
Thanks, Judge.
All right, just have a seat. Once you sign the reset form, you're excused.
Thank you.
Thank you.
Judge, we're stopping at 11, right?
Yes, we are. Hey, just give me a moment. Adrian Holmes.
He's going to be brought up.
He just requested him to just on the side.
All right. Deputy Laura, that's the last request. Randy Folsom.
Yeah, if you're going to court, at least wear a shirt and
All right, I
jeans.
noticed that you
That's
filed a
enough.
motion to suppress.
As a
Of course, we
defendant,
can't
at least.
Proceed with that today because we're currently in trial.
Oh, I understand, Your Honor. It's not a problem with that.
All right, so what we can do, and is that motion going to be dispositive or no?
Don't believe so, Your Honor.
All right, so what we can do is we can carry it with trial. How long do y'all expect this trial to last?
3 days.
All right, do you want a bench trial, jury trial?
Mr. Folsom, he's asking if you want a bench trial with the judge or a jury trial with the jury.
I'll go with you or jury, it doesn't matter.
No. Here's the thing, you have to make a decision.
Okay,
So with me?
Yes, ma'am.
All right, so with a bench trial, that means that the parties will present witnesses to me and I'll make the decision. I'll act as the jury to make a decision on whether you're guilty or not guilty, or whether something should be suppressed or not suppressed. You understand?
Yes, ma'am.
All right. Ms. Ferguson, when can we do a bench trial?
3 days, 2 days. Yeah. Okay. Been locked up, yeah.
Let me see. Do we have any trials the week of May 27th? All right, let's set this for a bench trial on May 28th.
Yes, Your Honor. Got that down.
All right, and you'll sign the documentation for the bench trial, please?
Yes, Your Honor. Will do.
Is that it?
And then upon
Yes.
sign that, maybe excused.
Yes.
Thank you, Your
All
Honor.
right, you're welcome. Okay.
And then on MTR, they can't compare with me, so it needs to be reset.
Hey. Let me mute us.
I'm just gonna say.
All right, just give me 2 minutes, guys.
Thank you. And then the other one is an MTR. Did you make this approach on those?
Okay, his name is, hang on. Juan Garza. Juan.
The court is going to start the trial again at 11. So.
Oh, yeah. That's right. Oh, the docket. I know you guys are gonna stop.
We're back on the record in 2023 CR 3545, John Hayes. As previously stated, the court has found violation of condition number 25 true. The court is going to grant the motion. The court will find you guilty. Do you all have an agreement with regards to time?
No, we don't, Your Honor.
You don't, Your Honor.
All right, state, what are you requesting?
Your Honor, based on the facts of the case and how injured the complainant was on the underlying case, the state does have an exhibit the state would like the court to consider in determining the appropriate sentence, but the victim did have dried blood, multiple large bumps on her face and head. She did have to go to the hospital. She was treated by EMS. Several witnesses saw the defendant kicking the complainant in the head outside. And so at this time, the state would offer exhibit 1, pending any objection from defense.
Any objection?
No objection.
All right, the court will accept into evidence state's exhibit number 1. All right, did you have a chance to see that?
Yes.
All right.
And Your Honor, at this time, the state would be asking for 6 years.
Oh, she was beaten to a pulp. Ooh.
All right, did you have a chance to see that?
Jesus. Yeah, fuck this guy. Fuck this guy all the way to hell.
Yes.
I don't care if
And
she
Your Honor,
contacts
at this time,
him.
the state would be asking for 6 years.
Yeah, fuck this guy.
Your Honor, we're asking for 4 years.
Off
Your
you
Honor.
fuck.
Mr. Hayes admits what he did was wrong. However, Mr. Rubio was intoxicated at the time. Just like he claimed, some of her postings with that she made to Mr. Hayes, that it was her fault. She was intoxicated when she made the communication with Mr. Hayes. So just as those times that she was intoxicated at that time. And I want the court to consider that. Mr. Hayes, he never been to prison. He's never ever had any other problems with the law, Your Honor. So we're asking
I don't give a
for
fuck.
the court to consider punishment.
If you do that to a woman, off you fuck.
Range.
If you do that to
All
a
right, this
person,
court is going to do,
off
as
you
previously
fuck.
stated, the court is going to find you guilty. The court is going to revoke. There's to be no contact with Samantha Hayes or Samantha Rubio. The court will order the therapeutic community. Court will sentence you to 6 years in the prison, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, oh, I'm so sorry. Can I have that back? I didn't check the appropriate box for you.
You are.
Yes.
He's already completed lifetime recovery, the inpatient.
Okay.
Completed last year, I believe. No,
90 days.
90 days.
All right, I'll give him credit for any time served in inpatient treatment that was successfully completed. And for the record, the court will note that the lifetime recovery was successfully completed. Again, with the trial court certification, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion and not the fact that you were on deferred adjudication. There is an affirmative finding of family violence. Again, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. And it's also because this is an affirmative finding of family violence. Do you understand? All right, we can go off the record. I'm ordering the therapeutic community for you. With regard to the therapeutic community, I have no jurisdiction to have them place you in that program, but they'll see that I'm recommending it, and you'll need to request it as well. You understand? All right, good luck to you.
Maybe, excuse Your Honor.
Yes.
Thank you, Judge.
You're welcome. Adrian Holmes. All right, if you're still conferring, I'll come back to you.
I believe that guy,
Justine Mayor Queen.
the only reason why this is the only case he has is because his girlfriend at the time, or wife, probably protected him. Now that's speculatively from my end, but no, that doesn't happen in a vacuum. Fuck that guy.
Good morning.
Today was my client's first setting post indictment. They gave her the indictment, Your Honor, but I had previously filed a motion to reduce her bond. In speaking to the state this morning, we realized that apparently the original bond that had been set was no longer in place because the bondsman had gotten off. So I actually have to ask to reinstate her bond, which the state has no objection to. I have the order, if you want to write it on there, to 75,000. They
Well,
just
now I'll
want,
need the bondsman to say that they have any no
or
objection.
not reinstate, I mean, to issue her a bond, to set a new bond at 75.
All right, and that's the same amount that was previously?
Yes, Judge, the
I'm-
original bond was 75,000, so our agreement was for that same amount, but with
Full house.
full GPS.
And my client asked that if you could waive the fees because she does not have any income right.
Okay.
Yeah, but even if that woman is initiating contact, battered girlfriends and wives who are subjected to that kind of treatment by their spouse goes both genders. There are plenty of men who are abused by their partners as well. Sometimes they have what is popularly known as the Stockholm syndrome. You know what you have, you don't know what you are going to get, and their self-worth is so low. It's so extremely hard to leave an abusive partner. Extremely hard. Not just because, at least it's comfort in knowing what you have. Then you have fear on top of that, and the fear, what will he do when he comes out? What will he do to me when that guy is paroled or the parole is over? They don't want to anger that person. Yeah, she wants him around, but the law says otherwise. And for some battered people, let's go back to the Depp v. Heard trial. Why did he stay for that long? Why did Johnny Depp stay with Amber Heard for that long? And many abused people stay because of fear, misdirected love, misdirected everything. It should be easy to say, why don't you just leave them? But it's never that easy.
All right, and the state is currently in a jury trial, so I'm going to recall this, and Ms. Ferguson, she'll need a reset form. So if we can recall this for May 20th.
Sounds good.
All right, thank you.
May 20th. I'll have you signed. Thank you, Judge.
You're welcome. You're welcome.
They're gonna have her sign it tomorrow.
Just one moment.
She just gave her a box, so she just wanted her to sign all this. Pay attention to Judge. It's funny. Judge, I think that's funny. Yeah. Thank you.
Daniel Morales. And no more files, please. All right, what is happening with this case?
Your Honor, we just got got an offer from the, prosecution today.
Okay.
A client has expressed his, willingness of inclination to accept that offer. I just know that the court scheduled today. Not sure that we would be able to.
We can
have
recall it for Thursday.
I would ask the court if it's okay, or is the court available for a plea tomorrow? Because Thursday I'm out of county.
Yes.
Okay.
All right, Ms. Ferguson?
Which will-
Yes, it'll be in the afternoon.
No worries.
All right, we'll come back on April 16th for disposition.
At 1:30?
Yes,
Okay, in person.
yes. Heather Pippin?
We're gonna have a plea, come back on Thursday.
Yes. All right, Norma, recall Pippin, the 16th, 1:30 for disposition? Yes.
Thursday.
Thursday, okay, the 17th.
What time?
9. Mhm. All right, Deputy Laura Pippin is the 17th at 9. Juan Garza. Are y'all ready to proceed on the motion?
No, Judge, the state did not have a chance to give us an offer. And so I know you were shutting down at 11, so I wanted to approach. I'm unavailable tomorrow and Thursday because my son-in-law is graduating from basic training and we're going to all of those events. So
Okay,
if we could have next week sometime, I'm happy to come work it out.
all right. What I can put you for is, Ms. Ferguson, recall this for next week. What do you want, 21st, 22nd?
Tuesday would be better. Is Tuesday?
All right, April 22nd.
Thank you so much, Judge.
You're welcome.
Thank you. Yep.
Bashan, that is Juan Garza.
I know we might not get to it, but I just keep in.
All right, who is here on Dustin Newkirk? Court is calling 2024 CR 010665, State versus Dustin Newkirk. Don't give me any more calls. Okay. All right, can I have parties announced?
Andrew Harris Adam for the state.
Matthew Allen for Mr. Newkirk.
And are you Mr. Newkirk?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor. I'm standing in for Mr. Lyles. Mr. Newkirk is in agreement with that, and Mr. Lyles has received and reviewed all discovery with him.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Newkirk, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
And I'll take up the motion to revoke after this.
Thank you.
Mr. Newkirk, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand? Just 1 second. I'm just trying to make sure these are the correct steps. All right, they are. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Newkirk, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Not at all, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Very much so, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargaining page with your attorney? Did you understand it?
I did, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 180 days in the state jail facility. The state will take in consideration 2024 CR 010664, 2024 CC 738030, Night mag number 767200. This is run concurrent with 2019 CR 13070, 2024 CC 738034. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead?
Guilty, ma'am.
State any evidence.
Contained in Exhibit 1 and attachments, Judge.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor. Well, I guess just he was in the Marine Corps for 8 years, 4 deployments, diagnosed with PTSD. We're hoping that once he has enough time, I believe that he'll be out fairly soon if the court allows this plea to go through and a motion to adjudicate. But he has already looked into a program in Houston for combat veterans with PTSD. And so we're just asking the court to follow that agreement.
All right, the court will follow your agreement, sentence you to 180 days in the state jail facility, give you credit for any time served. This will run concurrent with 2019 CR 13070, 2024 2024 CC 738034. Take in consideration 2024 CR 010664, 2024 CC 730. All right, 2024 CC 738030, night mag number 767200, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Going to proceed with 2019 CR 13070. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I did, ma'am.
Are you the same Dustin Chapman Newkirk who was placed on deferred adjudication in 2019 CR 13070 for the offense of possession of a controlled substance penalty group 1, less than 1 gram on August 13, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
State?
On or about the 26th day of October 2023 in Bexar County, Texas, the defendant Dustin Chapman Newkirk did then and there fail to register for the parenting class in violation of condition number 20.
How do you plead to that? True or not true?
State waives the remaining violation allegations.
Any objection?
No objection.
Did you understand by pleading true to a violation of condition number 20, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
I do, ma'am.
Court will find violation of condition number 20 true. Is there a proposed agreement?
Yes, Judge. Adjudicate guilt, revoke supervision. Thus punishment at 180 days of confinement in the state jail facility running concurrent with 2024 CR 010665.
That's correct, Your Honor.
All right, probation. Has Mr. Newkirk completed anything while on probation? And did he pay restitution?
Your first question, and I don't have any restitution order.
Okay. All right, you haven't done anything on probation. I understand that people have different issues that they're going on in their life. That's why I ordered certain conditions for you. This is what the court is going to do. Court is going to find you guilty, revoke. This will run concurrent with 2024 CR 010665. There's to be no contact with Victor Phillips or Megan Louder. There is to be the therapeutic community, and the court is going to sentence you to 300 days in the state jail facility. Give you credit for any time served. Court is going to recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor, just, he was confused. The individuals that were named, was that in the original plea bargain, I'm assuming?
Yes.
Okay, 'cause it was less than a gram case. Is there a way to see it so I can just show Mr. Newkirk?
Sure.
Thank you, Judge.
Judge, may I approach?
Yes. I'm sure that was due to something else being taken in consideration.
Oh.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand? All right. We can go off the record. When you're released from custody, if you can't find a place that will help you with whatever issues you may have, if I'm still here, you can come back here. I'll pick up the phone, call somebody to help you. All right? All right. Good luck to you.
Thank you.
You're welcome. Who's here on Adrian Holmes? And then after this, we're taking our recess. Hello.
Good morning.
Good morning. All right. So where are we on this case, counsel?
Judge, he got indicted February the 19th. This is the
Okay.
first setting.
Okay.
I've had a couple of attempts to see him through ICS at the jail. They have not brought him out.
Okay.
I think it would be to everyone's benefit if he was examined for competency.
All right.
And I just got discovery over the weekend. I'm going to try to go see him at the jail.
All right. And if there's issues with seeing him at the jail, just let us know. We'll arrange for you to see him here and I'll call the jail to see what's going on while your attorney can't see you. So Norman, let's recall this for May 27th.
Judge, they have a phone number that they gave. I got it
Mhm.
probably a couple of years ago to talk to them about when somebody's late or didn't show up, but they were not answering the phone yesterday for sure.
Okay.
So it's just, it's a hit or miss sometimes.
All right. Just let us know and we can have him brought over too for you to discuss things with him. All right. Thank you.
Thank you. Do I need to file a motion or we just do the
Oh,
order?
yeah, just follow the order and I'll sign it.
Okay, good. Thank you.
All right. Thank you.
Your Honor, before the docket's called, may I make a brief announcement with regards to Ruben Maldonado?
Can I see Ruben Maldonado? What's
The situation is, Judge, we did plea paperwork and we understand that the court's gonna take a break. May we come back tomorrow in the afternoon?
Yes.
For disposition?
Yes.
Thank you, ma'am.
That is a good question. I don't know. That's why I'm so confused.
All right, folks. That was the morning dockets of Judge Simpson and Judge Boyd. Now, they have started the afternoon docket at Judge Boyd regarding the sentencing. But, folks, I gotta eat. And then at 5 p.m., I have a stream with Dave and Andrew Branca regarding the Schur case. Mr. Schur is charged with murder. He claims self-defense. It is a white cop shooting black suspect in the head. And it will be interesting. It will be really, really interesting. It and might be some graphic stuff in it. So a heads up on that one. Heads up. Wahaha. So, but that is 5 p.m. I'm going to redirect you to that stream. Me and Dave will be dual streaming it. But until then, thank you for being here. It has been an interesting docket day again with both Judge Simpson and Judge Boyd. And thank you to Brandon for your $5 super chat. Thank you for becoming a new member. And thank you to Nana Misty for 1 year as a member. Thank you so much. And you guys, remember, folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay. See you in a bit. Bye-bye.
Sail the raven waves, brothers, axes high, shields strong. From distant lands we gather.